How to win at mediation. Hi, I'm Tom Friedman. I'm a lawyer in Nevada, and mediation is simply an informal meeting with you and your lawyer, if you've got one, and the insurance company and the insurance company's attorney. On the other side, a mediator is a person that just tries to bring the two sides together to reach a number that will make both of them less unhappy and resolve the case. So when you go to mediation, you have just three jobs. Your job number one is to demonstrate that the harm caused to you was caused by the person or the business insured by the insurance company in the other room. And so if you've got a lawyer, your lawyer's probably going to do this for you. They'll probably put together before the mediation what's called a mediation brief. It's essentially a little booklet. It has the facts of the case. And then if it's, say, a car accident, in order to show the other side is liable, they'll include something like a police report. Maybe the other side was ticketed, witness statements, recordings, videos, anything like that. The mediator's already going to have all that stuff. If you're doing this by yourself without a lawyer and you haven't done that yet, this is your time to show the mediator why the other side is at fault. So if you've got the police report, bring it. If it's a slip and fall, you've got video, bring it. If you've got witness statements, bring it. You need to show the mediator that the other side caused your injury. So any evidence you have to help with that, bring it along, show that to the mediator, and demonstrate why it is the other side needs to pay you. The second job you have in a mediation is demonstrate what your damages are. So if the other side's at fault, but you have no damages, you weren't hurt, you're not really going to get anything. So you need to show that you were hurt. So how do you typically do that? You're going to look at medical bills, bring them with you. If your attorney hasn't already submitted them, you want to show all your medical treatment you had as a result of the accident. If you lost work, you want to demonstrate how much money you lost from work. And the way you can do that is show what your average weekly, monthly payment is. You break that down to a day, and then how many days were you off work. So if you made $100 a day, you missed 10 days of work, 10 times 100 would be your damages. You also want to talk about how it affected your life. If you used to, golf every week, surf every day, skydive every other day, whatever your hobbies were, talk about what you did before you were injured, talk about what you did after you injured, how your life was affected, relationships, things like that. And this is important because you need to show the other side how this impacted your life, because literally this is very personal to you. The insurance company in the other room is being represented by a claims adjuster. That adjuster has literally hundreds of files they're managing at the same time. And so they need to get their files investigated, closed, paid, so they can move on to the next one. And so you need to make their job easy by giving them all the data they need to justify why they should pay you money in this file. So that's what you do on the damages side of it. Now, the third job you have is probably the simplest of them all. Don't shoot the messenger. That's it. So what's going to happen is usually if you're bringing the claim, the mediator is going to speak with you first. And you're going to show the mediator, what happened, your damages, all these things, why this is important in your life. And the mediator is going to go in the other room and talk to the insurance company folks. And the insurance company folks are going to give the mediator a number, and the mediator will bring that back to you. And you should know that the insurance company's never going to come out with their highest and best offer right out of the gate. In fact, you're probably going to get a number that's very insulting to you. And don't be insulted. It's just how they work. So what'll happen is the mediator, you'll come in, you'll say, I don't know, I want $100,000. And the mediator will come back in and go, well, you know what? They're offering you $5,000. They're offering you $10,000. Well, don't blow up. Don't kick the mediator. Don't get angry at him or her. It's not the mediator's fault. Don't shoot the messenger. It's just the way the process works. You want to have a good rapport for the mediator. You want the mediator to feel that you're a good person, that a jury is going to like you. And if a jury likes you, a jury is probably going to pay you money. And so you can express your disappointment in what the other side did. You can say you're upset about what they did. You can say all of that, but don't take it out on the mediator. So if a mediation goes as planned, you've got all your facts to show liability. You've got all your evidence with you to show damages. The two sides are going to come together. You're going to start up here. They're going to start down there. And, hopefully by the end of the session, you're going to meet a point where you're willing to accept what they're willing to pay, and the mediation is a success. There's no more litigation after that. You'll agree to a number. There'll be no depositions, there'll be no trial, there'll be no nothing. The only thing that happens after that is there'll be a settlement agreement put together. The insurance company is going to write a check, which goes to your lawyer. I'll do another video about that. And you're done. So hopefully this was helpful. Thanks very much for watching.